Greetings. Testing A, testing B, testing 1, 2, 3. All right. Looks like we're all here. And let's get started. Today we're going to be going over American jurisprudence, records and record keeping. And we're going to be focusing today on public record laws and crimes. So let's get right into it here. We're going to start right out into it with the correction or change of public records. Some jurisdictions recognize a private right of action to contest the accuracy of public records. Under some jurisdictions. Okay, so now here's one of the important things to remember with American jurisprudence is that we're trying to look at this from a common law perspective, but it's really through the system of American jurisprudence, which is its own style. That's I don't know how you describe it best, but maybe an amalgamation of common law, statutory law. There's a lot of aspects to it that have to be taken into account. And what these volumes of American jurisprudence do is they try to bring in all these different elements so that you can build an effective case. And this is part of what they do here is by saying things like some jurisdictions. So it's up to the person practicing their law to go and find out what your jurisdiction recognizes in regards to these rights. So let's see here. Some jurisdictions recognize a private right of action, a private right of action to contest the accuracy of public records. So some jurisdictions, you have a right of action to contest the accuracy of a public record and to correct public records. So you have a right to correct your public records or to compel. Of course, since you're not going to be the one to do it, you can compel or force a local department to keep accurate criminal records or to compel the correction inaccurate police records. However, a statute requiring agencies to maintain procedures designed to ensure that public criminal records are complete and up to date did not create an implied private right of action. So let's follow this. Remember, in American jurisprudence, everything is written for a reason, and we want to just be clear on what the meaning is here. So let's continue. However, a statute, if your jurisdiction is under a statute requiring agencies to maintain procedures designed to ensure that public criminal records are complete, so there must be a statute requiring an agency to maintain a procedure that's designed. The procedure must be designed, not just a procedure, but a procedure that's designed to ensure that public criminal records are complete and up to date, did not create an implied private right of action, absent an express provision. So what that means is that a statute requiring an agency to maintain procedures, right? It did not create an implied private right of action. So they can't use a requirement for maintaining procedures to imply a private right of action unless there's an express provision. So we'd have to look at footnote 5 to really get the details of what that really means. And it's just a case law and common law, 2019, or Connecticut law, I'm sorry. This is why they put it twice. So it's 2019 Connecticut, Watson versus Caruso. So that would be a case to see further detail if we look at the text of that case. By one standard, absent the government's assumption of a special duty, the government's failure to maintain accurate records cannot form the basis of a negligent suit by a person affected by erroneous record keeping, even if the government did not follow its own procedures. Interesting here. Let's look at this again. By one standard, now this is only one standard, whether it applies in a particular situation or not, depends. Absent the government's assumption of a special duty, the government's failure to maintain accurate records cannot form the basis of a negligence suit by a person affected by erroneous record keeping, even if the government did not follow its own procedures. So, without an assumption of a special duty, it's going to be hard to get a basis of negligence in a lawsuit if you're affected by erroneous record keeping, unless it's a special duty by the government. So let's keep that in mind. Reminder, under the Federal Privacy Act, an individual has a right of access to records, including the right to have records amended or corrected. Okay, do we still have anyone in here? If there's anyone in here, go ahead and hit the like or send something in the comments to know that we're being broadcasted well. It seems like we are. But I never know until I see it. Let's see, is it coming through? Yes. Okay. So let's continue here. Statutes may require the correction of a recorded document known to be invalid as totally and completely without merit, or without merit and futile. So statutes may require the correction of a recorded document known to be invalid as totally and completely without merit, or without merit and futile. So statutes may require the correction. Let's see, a statute authorizing court clerks or deed registrars to remove fraudulent documents from the public record was not enacted for the benefit of the officials, but merely offered guidance in the performance of their duties, to give the person presenting the document to power to commence a suit to prevent the officials from removing the document. So statutes may require the correction of a recorded... Oh, okay. So if the document is known to be invalid, then a statute requiring the correction of it is completely without merit and futile. Statutes may require the correction of a recorded document known to be invalid as totally and completely without merit, or without merit and futile. So there we go. So if the document is already invalid, some statutes may require that if you do record it, you can't do a correction of it. A statute requiring that would be completely without merit and futile. Oh, the correction as totally and completely without merit and futile. So correcting an invalid document may be required by a statute. So this is why it's hard to read this sometimes, but as we read it more, we get more within the way they write so succinctly and terse statements, so that they keep it very brief as far as the text goes. So give me one moment here. Okay. So a statute authorizing court clerks or deed registrars to move fraudulent documents from the public record was not enacted for the benefit of the officials, but merely offered guidance in the performance of their duties and give the person presenting the document to power to commence a suit to prevent the officials from removing the document. So statute authorizing court clerks to remove fraudulent documents was not enacted for the benefit of the officials, but was offered in guidance so that the person that was presenting the document was given the power to commence a suit to prevent them from removing it. So that way, if an official wanted to remove a document, you would have the power to bring a suit so that it would be judged in a court of law before that official could remove a document or claiming it's fraudulent. A statute authorizing the state registrar under certain circumstances to change the record of the birthplace of an adopted child so as to protect the confidentiality of the birth parents does not violate the Equal Protection Clause of the federal Constitution by precluding the adoptive parents of a foreign-born child from changing the child's place of birth on the birth certificate. Wow. Let's unpack that one, because that's a heavy one there. So a statute authorizing the state registrar under certain circumstances to change the record of birthplace of an adopted child so as to protect the confidentiality of the birth parents does not violate the Equal Protection Clause of the federal Constitution by precluding the adoptive parents of a foreign-born child from changing the child's place of birth on the birth certificate. So I guess the Equal Protection Clause, it's not going to be violated if you're doing it to protect confidentiality of the birth parents. All right. Practice tip. When an arrest was mistaken and lack of culpability, we know what culpability is, right? No? Let's look it up. And today we're using, of course, Black's Law, 9th edition. Oops, let's get there. And we're going to be looking up culpability, right? All right, just give me a moment here. We're going to look it up in the, I'm going to look up a little bit quicker. This one doesn't search well. None of it searches well because it's actually scanned, so. Another reason why it's always easier to do this stuff with the paper documents. There we go. Oh, man, that was a quick one this time. 463. All right, culpability. Here it is. This comes with culpabis, adjective, Latin, historical, guilty. So culpability is blameworthiness, the quality of being culpable. Culpable is guilty, blameworthy, or involving the breach of a duty. Okay, and except in cases of absolute liability, criminal culpability requires a showing that the person acted purposely, knowingly, recklessly, or negligently with respect to each material element of the offense. Wow, so that's to each material element. Let's read this further. The concept of culpability is used as a reference point to assess the defendant's guilt and punishment, even though, in the two contexts, culpability denotes different aspects of the defendant and the murderer. At the guilt phase, culpability is most often used to refer to the state of mind. Culpability refers to the state of mind most oftenly that the defendant must possess. So you must have a state of mind to be culpable. Also, at the guilt phase, culpability may reflect a broader judgment about the defendant. When he is culpable for his conduct, it means he is blameworthy and deserves punishment. At the punishment phase, the concept of culpability stands as the benchmark for when the death penalty is an appropriate punishment. There you go, culpability. Pretty intense definition, and that's why we stop and pause to look at these things, because sometimes you learn more than you really intended to just by looking up one word. When arrest was mistaken and lack of culpability, right, the blameworthiness has affirmatively been shown. The appropriate remedy is not to destroy or seal the record, but to clarify the record by a notation reflecting the fact that no grounds of culpability existed. Records of such an arrest that have already been disseminated need not be returned, provided that suitable exculpatory explanations are sent to all persons or agencies in possession of them. And I believe we looked up exculpatory. I love these words. They're so hard to say sometimes. Exculpatory. And never look at this stuff too many times. So let's just look into our Black's Law. And it's 665. Oops. There we go. So, well, let me get the full definition here. So oh, wait, that's not the right page. 676. There we go. So, exculpate is to free from blame or accusation, to exonerate. Okay. So let's read this one more time. The practice tips. So practice tips are basically if you're working a case, here's something, a tip you're getting from American Jurisprudence. When an arrest was mistaken and lack of culpability, right, the blameworthiness has affirmatively been shown, the appropriate remedy is not to destroy or seal the record. Remember, we're talking about records here. Not to destroy it or seal it, but to clarify the record by a notation. By a notation reflecting the fact that no grounds of culpability existed. That's one fact, right? It needs to be noted on the record. Record of such an arrest that have already been disseminated need not be returned, provided that suitable exculpatory explanations, right, exonerating explanations, are sent to all persons or agencies in possession of them. So you have to have a document trail where that's been disseminated, and then all persons need to be sent the exculpatory explanations. Then we have a cumulative supplement here with cases. Here's one. When a parent petitions to change a minor's child's gender marker on a birth certificate, similar to requesting a name change for a child, the appropriate standard is whether the change is in the child's best interest. And that's 2021. So we're getting, here's one of the gripes I kind of have about the courts these days, is that our common law is being so corrupted by these judges. Indiana, 2021. Appellate Court. All right, on to the next chapter here. The cancellation or expungement of public records. Okay, do we still have anyone here, is the question. Am I still streaming? Okay, generally, a recording, so again, we're on the cancellation or expungement of public records. So expungement's another word that we probably should have a better detail of. Oops. To expunge, to erase or destroy. The trustee wrongfully expunged the creditor's claim against the debtor. 2. In parliamentary law, to declare a vote or other action null and outside the record, so that it is noted, here's that notice again, in the original record as expunged. So here we're talking about having something corrected as opposed to being expunged as a notation in the original record. See this? How important it is to look at these definitions. That's in parliamentary law, but somehow it's creeped into here in a common law. As expunged and redacted from all future copies. That's not what we're claiming here. Also termed rescind and expunge. So let's get back to AmJur here. So that's the expungement. That's quite different from what we were talking previously about the correction of or changing of, right? So we're going now from the correction or changing of documents. And again, we had this example here of an arrest record that if you're exonerated, then, exculpatory is the term they used, then it must be noted in the record, not have the record expunged or rescinded. So let's continue here. Cancellation or expungement of public records. Okay, so erasing and destroying, canceling. Generally, recording a subsequent document is the only effective way of removing a prior invalid recorded document. So filing a document after is the only effective way of removing a prior invalid recorded document under a view that the physical removal of invalid recorded documents is expensive, time-consuming, and essentially pointless. And the court may have no authority to direct the expungement of records of public bodies. The expungement, remember the destruction of public records, is an extraordinary form of relief, but may lie within the court's inherent and statutory authority and equitable power, subject to all applicable criteria, to invoke the court's jurisdiction to grant an expungement, as may include a showing of usual and exceptional circumstances, that the interests of the applicant outweigh the legitimate interests of the government to maintain the record. So the interest of the applicant must outweigh a legitimate interest of the government to maintain the record. So let's look up a couple words here. Equitable we've looked up before, and I'd like to just do it one more time because there are some concepts about equity that I think are not given as much attention as they should. And it becomes something that, if we understand it better, that we'll have better ways of expressing this concept when it does creep up, because it involves, I believe, more of a historical concept. Yeah, here we go. Wow. Almost there. Equity. Yeah. Here we go. What is that? Equity, there it is, perfect. 647. Equity, it's a fairness, impartiality, even-handed dealing, right? The body of principles constituting what is fair and right. Natural law and equity, what's fair and right. The concept of inalienable rights, rights that can't be taken away, reflects the influence of equity on the Declaration of Independence. So here's, again, I just want to reread some of this here. In its popular sense, equity is practically equivalent to natural justice, but it would be a mistake to suppose that equity, as administered by the courts, embraces a jurisdiction as wide and extensive as that which would result from carrying into operation all the principles of natural justice. See, there are many matters of natural justice wholly unprovided for, from the difficulty of framing any general rules to meet them, from the doubtful wisdom of a policy of attempting to give legal sanction to duties of imperfect obligations, such as charity, gratitude, and kindness. You can't prescribe kindness or gratitude or charity to people by law. A large proportion of natural justice is, in its widest sense, is thus not judicially enforced, but is left to the conscience of each individual. So that's why and then the other part of equity is understand that equity was always left between the High Court of Chancery, right? The definition that somehow made it outside of being judicially forced and in English law, right? So it was basically, here it is, let me get to the part here. In order to begin to understand what equity is, it is necessary to understand what the English High Court of Chancery was and how it came to exercise what is known as its extraordinary jurisdiction. Every true definition, listen to this, of equity must, therefore, be, to a greater or lesser extent, a history. So this is why it's important to understand a simple word like equity, that this it's rather suggestive than precise and invites inquiry rather than answers it when we try to give a clear definition like this. And it must necessarily be so because equity in its technical and scientific legal sense means neither natural justice nor even all that portion of natural justice which is susceptible of being judicially enforced. It has, when employed in the language of English law, a precise, definite, and limited signification, and is used to denote a system of justice which was administered in a particular court, the nature and extent of which system cannot be defined in a single sentence, but can be understood and explained only by studying the history of that court and the principles upon which it acts. So, again, we get back to history of law, and that's where American jurisprudence comes from, because this has been part of a continuum of progressing common law into a form where the statutory, common law, equity, all these things were always handled in different areas, it seems, and they've come together in our system of governance. And that's what we're focusing on learning about today and exploring deeper. So let's continue. So again, the expungement of public records is an extraordinary form of relief, but may lie within the court's inherent and statutory authority and equitable power. Again, this could be a historical power of equitable power because it's not prescribed directly between statutes, right? And subject to all applicable criteria to invoke the court's jurisdiction to grant an expungement. So it may lie within the court's inherent, right? It's an extraordinary form of relief, but it may lie in the court's authority to do so, subject to all applicable criteria to invoke the court's jurisdiction to grant the expungement. So they must have jurisdiction, all the criteria to invoke that, as may include a showing of usual and exceptional circumstances. So extraordinary form of relief requires exceptional circumstances. That the interests of the applicant, right? This is the person, the applicant, making the wanting to have the expungement, right? Outweigh, or the other way around, I guess, the legitimate interest of the government to maintain the record. Oops. Or that, or that the record was obtained through fraud. Oh, geez. So, subject to all applicable criteria to invoke the court's jurisdiction, that the interests outweigh the legitimate interests of the government, or that the record was obtained through fraud. So it can be expunged if it was obtained through fraud, it seems. When a person's constitutional rights would be seriously infringed by the retention of public records, a court may, in its exercise of this inherent power, right, expunge those records. So there you go. Your remedy, if your rights would be seriously infringed by a retention of a public record, the court has the inherent power, and it may exercise that power to expunge those records. In certain classes of cases, the courts of equity have always had the power to inquire. Sorry about that. Always had the power to inquire into and correct mistakes, injustices, and wrongs in both judicial and executive action. However solemn the form that the result of that action may assume, if it invades private rights. And by virtue of such power, the final judgments of court of law have been annulled or modified, and patents or other important instruments issuing the executive branch of the government have been corrected or declared void, or other relief granted. Wow. Certain cases, classes of cases, right? Courts of equity. Remember, the equity is when they're not issuing something for like a monetary damage or anything like that, but to try to, it could be through injunctions or other kinds of actions to bring about a remedy. I've always had the power to inquire into and correct mistakes. So they've always had the power, the courts, to inquire into and correct mistakes of injustices and wrongs in both judicial and executive action, however solemn the form that the result of that action may assume, if it invades private rights, and by virtue of such power, the final judgments of the court of law have been annulled or modified. So if you're invading private rights with these judicial decisions, right, from the wrongs in judicial actions, that in patents. Okay, yeah, so you have private rights with patents and other important instruments. Void or other relief granted. So this gets into be difficult cases here. Definition, expungement, which we looked up too, but let's see what it says in American Jurisprudence, because this is going to override what we just wrote if there's any differences. Expungement may be defined to mean the removal of a record from public access, but not mean destruction of the record, as the expunged record is confidential but remains available for use by law enforcement agencies and other specified persons and agencies. Expungement is a term of art. A term of art. So we were looking at a nice definition of it, and that's not what it is. It's not destruction. It's a term of art, used almost exclusively in the context of statutes providing for the erasure of records and references to a particular criminal record when certain statutorily prescribed conditions are met. So here we got cancellation or expungement. So there seems to be some distinctions here, and we got some great, see, unpublished, unnoticeable, great. We have some case law here to look up if we want to have more details. And that's great stuff there. All right, so the next section here is laws for the removal or destruction of public records generally. And I'd like to take off on this next time because now we've had this background. This is the really hard, dry stuff that I keep an audience with, and I appreciate everyone that stayed here with me for it. Hey, we got Los Angeles Spike in the house. Yeah, so this is the reason I like to do it like this is because we have to have this essential part down. People can hear this on their own time. There's probably not a whole lot of feedback at this point because we're going over the definitions. I'm doing a deep dive into the meanings of words. We're looking at conflicts of meanings of words, conflicts of where statutes and federal and cases and other kinds of private interests and rights could come into play. And we're also looking through practice tips and other kinds of observations that might help us should we ever have to find ourselves in any of these kinds of positions, which would be not too good. But it's very good that we're able to see this stuff today and have something like the internet to be able to have a great resource to share this type of information that used to cost just such ridiculous amounts of money to be able to access. And then, of course, law school to be able to get someone to explain it to you like this. And again, I'm not a lawyer, a law expert. I'm not professing to give any kind of legal information or law practice information whatsoever. This is merely a discussion or a review of the principles and history of American jurisprudence and how it applies in our courts today. And that's all there is. There's nothing intended as far as advice or recommendations for anyone. Just use it your own for your own enjoyment. And again, I'd like to thank everyone for coming in today to see this. I think that we have a great panel here that usually comes in. I know it's a little thin crowd tonight. I appreciate everyone here. Next time we're going to be taking up right on the laws themselves. So part 2, please make sure that you're tuned in for that because it's going to be it'll be another great eye-opening, I hope for everybody, episode and a continuing journey on our exploration of American jurisprudence. Again, I want to thank everyone for attending and peace out.